part heard appeal in the matter of Sintes and the London Borough Tower Hamlets.
Yes, Mr. Coffey.
My lords, my lady, yesterday afternoon I addressed you on the appellant's challenge to the nuisance ground 1C, as I referred to it. Today I intend to focus on the challenge to the remainder of the first ground, the negligence challenge, if I can put it that way. In doing so, I propose to focus on the making things worse limb, if I can phrase it that way, only briefly touching on the sufficient control of a third party limb. As I indicated yesterday, we are not arguing this is an assumption of responsibility case. After that, I will cover grounds 2, 3 and 4 in turn.
Yes.
Turning first to ground 1, if I may ask the court to turn up Tyndall in the authorities bundle behind 21. And to page... It is to page 44 of that authority. I think I'm on paragraph 44 of that authority, which appears behind page 624.
Mr. Coffey, my hearing's not very good.
I
So
do apologise,
if
my
you could
lord.
very-
Yes, I will endeavour to keep my voice up.
We all thought yesterday you were being a bit quiet.
I'm grateful for the indication, my lord. I will certainly keep
We
it
don't
up.
want to miss a word of it.
Sure you don't, my lord.
Yes, page 624.
Page 624, paragraph 44, and here at this is Lord Leggett and Lord Burroughs summarising the principles from the cases that they've analysed. And at Roman 1, in essence, they are drawing the fundamental distinction between making matters worse, where a finding of duty of care is commonplace and straightforward, and a failure to confer a benefit, including failures to protect a person from harm, where there is generally no duty of care owed. Moving down to the next page, 625 to Roman 5, I do intend to return to those intervening Roman numerals in due course, but for the purposes of my current submissions, at Roman 5, their lordships state that, although not made out in any of the above cases they had given examples of, there are exceptions to that general rule that a failure to confer a benefit or a failure to protect a person from harm will not give rise to liability, and then they set out what those examples are. For example, the defendant has assumed a responsibility to do so or had control of a third party. The two elements that come out of that is that on the facts of this case, the only two potential manners in which a duty could arise are the failure, or I beg your pardon, are the making matters worse limb or the sufficient control of a third party. And as I said, I will be focusing on the making matters worse limb. In doing so, if I could ask the court to turn to tab 6 of the core bundle, which is the judgment below. And this begins at page 70. The first paragraph to which I'll be turning is 169 at 111.
Yes.
As I've indicated, there is nothing in this judgment to suggest that there was an assumption of responsibility to the defendant upon which the judge based his reasoning. Rather, the judge's findings, the first one that I'm bringing to you at paragraph 161, here we see the appellant was responsible for the existence of the market. The judge says, in my judgment, the SSLTC, and that's what he's referring to as the standard trading conditions that we've seen yesterday, into which we will come in due course. clearly outline a situation in which the defendant has assumed responsibility for the existence of the market and the rules, license conditions within the market which the market traders operate. Those license conditions, key elements of which I've set out at 49 and 64 above, clearly envisage a high degree of control of market traders. They are coupled with sanctions. A market trader is unable to bring their stall to the market without complying with those conditions and submitting to the sanctions regime and paying the requisite fee.
So on any view, he's confused in that paragraph because he conflates assumption of responsibility with control, which you're treating as separate.
Rather than confused, my lord, I would say there is perhaps an unfortunate choice of the word responsibility in that sense.
Okay, unfortunate choice of words, confused.
My lord, I would say it's clear from what it is the judge is saying responsibility has been assumed for, and that's the existence of the market. Were the judge in this case to be basing his reasoning on assumption of responsibility in the uppercase terms, if I can put it that way, as in the assumption of responsibility cases such as Phelps, etc., he would clearly have to be referring to an assumption of responsibility to the claimant. So he could not be saying there was an assumption of responsibility here to the market, therefore we fit squarely within Phelps specifically. That would have to be to the claimant. Here, there is perhaps, as I said, an unfortunate choice of the word responsibility. It could easily have been said the defendant was responsible for the existence of the market. It's a subtle distinction, but it may perhaps have avoided some of the confusion.
If you were going to look overnight, if you could, at the creation of the market.
The creation of the market, my lady, yes.
Did you get anywhere on that?
My lady, where I got to was that the license conditions, and perhaps we can turn those up now in order to make this point. The license conditions appear at page 87 of the supplementary bundle. The heading, before we even get into the conditions of this document, says regulation made by the London Borough of Tower Hamlets pursuant to sections 27(3) of the London Local Authorities Act 1990 as amended. Returning then to the 1990 Act and to the section to which my Lord Justice Stuart-Smith took me, which is in the authorities bundle behind tab 1. And we are at section 41, which appears at page 20. And this is the saving section for markets or fairs held in pursuance of any statute, royal licence, royal charter, letters patent, etc., or from time immemorial. Nothing in this act shall affect those. In my submission, were this a case where this was one of those markets, the regulations and the conditions governing it would not be made under section 27(3), as is expressly set out at the head of the conditions. There is nothing further that I have seen or that has been adduced to suggest that this was anything other than a street market that was governed by the 1990 Act. It may very well be that market trading existed in this area prior to the passage of the 1990 Act.
Sure.
But upon coming into force of that Act, my lord, the situation changes. And now the local authority is vested with the requirement to pass the resolutions indicated in section 24 in order to say Whitechapel will be designated as a market street. They will take all of the reasons for doing so into account, I'm sure, but that act begins the train of actions to which I will refer in due course.
If we go back to the recitals to the Act, which we looked at yesterday, paragraph 3 there says it's expedient to ensure that London Borough Council can exercise more efficient control over street trading. That's the purpose of this Act. So this, what probably was a market that was already in existence, street trading was taking place there, and the Act allows for the control of that. But it doesn't, I sense that your submissions were going down the route of effectively Tower Hamlets created this market.
My submissions would go down the route of it created the market in its current guise. What I mean by that, my lady, is that prior to the passage of this Act, and prior to, in particular, Section 23 and Section 38, if trading was taking place there, it would not have been an offence under the London Local Authorities Act. Once this Act comes into force, in order for street trading in the Whitechapel Market area not to be an offence, there are a number of conditions that must be met. The first is that the local authority must designate it as a licensed street, and then the traders must be licensed by the local authority.
It's quite difficult for us to be to reach a valid conclusion on this, because Schedule 2's got a list of about 24 varied regulations which are all repealed. And speaking entirely for myself, I don't know which one of those may have covered Whitechapel or what it said, and no one's investigated the prior history.
But my lord, the point that they were repealed is exactly the point.
But we don't know what they said, so we don't know whether what the 1990 Act says replicates or it differs significantly from.
And that's the distinction that I make between the market trading existing simpliciter prior to the 1990 Act and the market trading existing in its current guise. So the market trading post 1990 exists in such a form whereby it is managed, controlled and regulated by the local authority in the manner set out under the Act, in the licensed trading conditions, and then in the standard operating procedures.
I mean, surely we can't say anything more conclusive than that after the 1990 Act, it was an offence to carry out street trading. It would have been an offence to carry out street trading at Whitechapel unless you had an appropriate licence from the local authority, and the local authority had a power to give, but not a duty, to give licences under the terms of the Act, and did so.
Yes, but the local authority was also empowered not only in giving those licenses to simply license the trading. So this isn't simply saying you may trade on this street. The powers that it has is to license that trading and to impose conditions upon that trading as it sees fit. Certain conditions are required under the Act, and the other conditions that it sees fit to, and perhaps it's worth going back to the Act. I know my learned friend did open the Act to you in this regard. This all comes under Section 27 in terms of the conditions that can be created. And it is those additional aspects that enhance the degree of control and management over the market that, in my submission, changed qualitatively the nature of the market trading in the area.
The only, I can go with you most of the way, but at the moment I don't feel able to accept your submission that it changed in 1990, because for all we know, it may have preceded. So aren't we safer simply, and I don't think it's essential to your submissions.
I don't think it is, my lord. I'm sorry, I interrupted you. You were going to say, is it safer?
It's not essential to your submissions whether it changed in 1990 or not. This is the regime from 1990.
Quite right, my lord.
Okay. And it's all pursuant to a statutory power. And everything that is done is a statutory power.
It is all pursuant to statutory power, but again, that in and of itself, as is very clear from the authorities that you've been taken to by my learned friend, is not sufficient to immunise a local authority for exercising that statutory power in a negligent way. And the submissions that I hope to make good today are precisely that.
Okay.
Returning to the judgment below, we were in the core bundle. We were at paragraph 169. On the same page, if I could come down to 173, and again another finding from the judge that the way the market operated was squarely the responsibility of the defendant. The defendant was, I find, in control of the market. Moving to page 114, and this is paragraph 182. This is when the learned judge references the nuisance constituted, but again it's a point about control that I say has bearing across the judge's reasoning. The presence of the poles therefore constituted a public nuisance on the highway. Their presence, along with that of the trolley upon which they were placed, was, on the balance of probabilities, related to and caused by the operation of Whitechapel Road Market by the defendant. My Lord Justice Stuart-Smith yesterday queried how is it that the market was permitted to be run in such a way as to create that nuisance. Again, I hope to make that good as I go through. If I could take the court forward to paragraph 129, or beg your pardon, paragraph 255 of the judgment, which appears at 129 of the bundle. The judge concludes that
Sorry, which paragraph?
I beg your pardon, my lady, 255, page 129. The judge here concludes that the trolley and scaffolding poles would not have been present but for the defendant's licensing of the market.
What does that mean?
Putting it another way, of course that's true, but so what?
Well, this will come in due course to the submission I'm going to make about the necessity of looking at the activities of the defendant as a whole, as we see under paragraph 45 in Tyndall, where the example of the car, which is taken from Stoven and Weiss, being parked at the top of a hill without a handbrake being applied. It's said that you can look at the handbrake not being applied as simply an omission. However, when you look at the activity as a whole, it is the driving of the car to the top of a hill. And this will come on to the point about wrongfulness raised in Mitchell. No problem with parking the car at the top of the hill. The wrongful act arises by the failure to apply the handbrake, which makes the entire activity one that creates or increases a risk of harm or danger, and as a result can attract a duty of care. Now, I will go to the authorities to support those submissions, but just in response to my Lord Justice Bean's question, that's ultimately the point here. That the simple submission is the judge below found that the existence of the market and the manner in which it was run were essentially causative of the presence of the poles, because had the market not been licensed, had it been run in a more stringent way, and I'll come on to the inspections regime, those poles would have been either not present in the first place or would have been detected and removed. And it is that aspect which is the failure to put the handbrake on, if I can put it that way. Now, the issue with that, my lordships may feel, is that there is an intervening act of a third party. To that objection, I do intend in due course to take you to Haynes and Harwood, which was not the case itself, but there is the reference to Haynes and Harwood, where the parking of a horse-drawn van on a street and then being left unattended created a duty when a child threw a stone at the horses and caused it to bolt. Again, the parking of the van in a busy highway, horse-drawn van, not inherently wrongful in and of itself. The failure to attend that van, so the walking away and leaving it there, is the wrongful act that comes in in Lady Hale's terms, and indeed Lord Rogers' terms in Mitchell. That's the wrongfulness that creeps into the act when taken as a whole. And then the third party child throws the stone, but it is the owners of the van who were responsible vicariously for the failure to attend that owe the duty of care.
I think if we're looking at paragraph 255 of the judgment, we have to look at the next one.
Yes, my lady, I was just going to take the court to that. The very next one down, the trolley and the scaffolding poles over which the claimant tripped were an obstruction of the footpath and constituted a public nuisance, which was created as a result of the manner in which the defendant permitted the market to be run.
That sentence just simply isn't right, is it? It wasn't created as a result of the manner in which the defendant permitted the market to be run.
When viewed as a whole, my lady, and this comes back to the Haynes and Harwood example that I was giving and that analogy, when viewed as a whole, the actions of the responsibility for the existence of the market in its current guise, the control, management and regulation of the market, and then the aspect of that control, management and regulation which I hope to make good in due course, that is deficient, so not having sufficient and appropriate inspection regime taking place, albeit it's recognised by the SOPs that it should have, that is the management of the market, that is the control of the market that permits that nuisance to occur in the language of this section, because but for all of those activities taken as a whole, either the poles wouldn't be there or they would have been identified and removed.
I don't see how it can be said to have been created. It was created by a market trader.
Again, perhaps then an infelicitous use of terms and continued would be the appropriate terminology here. But again, the thrust of what the judge is saying pervades throughout the course of the judgment, if I may put it that way.
But I have to say, for me, it's one of the difficulties with this judgment is that there's a lot of infelicity of language and some broad statements which, even taken on their own, are tricky. Because, for example, on 256, the defendant did not permit in any real sense, or in one sense, did not permit the market to be run in such a way as people deposited dangers on the highway. It's clearly contrary to license conditions, which is the basis of the permission. And then you are into what you're really talking about is enforcement, which again is the exercise of a statutory power. And you walk, at least on one view, straight into Tyndall.
Well, not if that enforcement is done in a negligent manner, my lord.
Yes, absolutely. The whole point about Tyndall and the dozen cases that lead up to it is that in the exercise of a statutory power, doesn't matter how careless or foolish or whatever you are, the starting point is that unless you make things worse, there's no duty of care.
And my submission in that regard, my lord, is that making things worse, and whether that occurred, and this comes from paragraph 45 of Tyndall, and those intervening Romans that I will take the court back to in due course, must be understood in the context of the activity as a whole. Not simply...
As a whole is that I'm going to put it slightly tendentiously, but a local authority with limited resources has not simply abandoned the market to the traders, but takes steps, A, to enforce the license conditions, and B, to do things like organising the waste collection and things like that. But that's all pursuant to statutory power.
It is all pursuant to statutory power, and the manifestation of the inspection or enforcement regime, or where that comes from, is the standard operating procedures, which I will take the court back to for this point, which were imposed on itself by the defendant. So the standard operating procedures were, when they were written, in the defendant's view, the reasonable actions necessary in order to maintain a safe and appropriately run market. Now, I will come in due course to why that's necessary and the foreseeability of risks that came with the creation of the market, and why then one could see SOPs like this would be necessary. The wrongfulness that creeps in, so the abandoning of the horse, the leaving of the handbrake off, is the failure to comply with those standard operating procedures, as was found by the learned judge below, by not having a markets inspection conducted in that last late shift. And again, I will take you to the evidence that it is the case that this was not a one-off. The evidence below was that on probably 2 occasions per week, there would be no late officer on, despite the standard operating procedures identifying that as being necessary.
But so what?
Well, again, so it is a consistently tolerated breach of the minimum necessary standards that the council identified themselves were required to keep this market safe.
Your argument comes down to, having licensed this market, the council were under a duty to inspect regularly.
Yes, my lady. Because that whole activity, and this is where the foreseeability aspect comes in, inherently, as my Lord Justice Bean said yesterday, it's common sense that market traders left to their own devices might leave things lying around the market. But I don't need the court to rely on common sense, because I will, in due course, take the court to various evidence that was seen below that demonstrated that, and indeed the court below found, that this was a known problem in the Whitechapel Market area, the abandonment of materials, the obstruction of walkways, etc. And in those circumstances, it makes it all the more important and all the stronger the imposition of the duty on the local authority to have that functioning inspection regime in place.
So your submission rests on A, foreseeability that market traders will not comply with their license conditions, and B, the knowledge that that may happen and has happened is said to create a duty upon the council to ensure that it doesn't happen.
Not quite, my lord. It is the combination of the responsibility for the existence and control of the market, the foreseeability point which you have rightly...
Hang on, I want to get this down. It's a combination of responsibility for the existence of the market
and the control level that is exercised over it. The foreseeability of the precise hazard that occurred here. So market traders leaving materials in or around the market in such a way as to create a hazard to pedestrians. Added to that, the self-imposition, if I can put it that way, of standard operating procedures which the local authority identify as needed in order to mitigate that risk. And then again, returning to the need to look at the facts as a whole, the failure to carry out that specific, those specific SOPs and the requirements thereunder. Now, the challenge that may come back is, but Mr. Coffey, that failure to carry out is the breach of the duty. How can it be the breach of the duty and the creation of the duty? And the response to that, again, is in the example given at 45 of Tyndall, the leaving of the handbrake off on the top of the hill would be both the breach of duty and the part of the act that is wrongful that creates the duty of care to the third party. Similarly, in the Haynes and Harwood style example, the failure to attend the horses is both the wrongful act, if I can put it that way, that creates the duty, but also it is the breach of the duty in the same way. So I say that that is not detrimental, or that is not fatal to the submission that I'm making, that both the failure to comply with those SOPs is the wrongfulness that creeps into the activities as a whole, but also constitutes the breach.
Okay, thank you.
The leaving of the handbrake off doesn't create the duty. The duty is, as a motorist, to drive safely, and it's the whole activity.
Yes, quite right, my lady. But again, to use that analogy, the duty would be to ensure that activities that you undertake pursuant to statutory powers are done safely.
There has to be a duty. So it's somewhat circular.
Well, again, and this is the Haynes and Harwood point. Again, nothing inherently problematic about parking a horse-drawn van on a busy, crowded street.
Oh, yes, there is.
Or perhaps at the time Haynes and Harwood was decided.
If you, there's certainly something seriously wrong if you leave your thing, your horse-drawn cart at the top of a hill without a brake on.
But my lord, again, I'm breaking down the specific aspects of what happened in Haynes and Harwood. So, at the time of the case, simply parking a horse-drawn van in a busy street would not necessarily be problematic until that horse-drawn van is left unattended, and it's the lack of attendance of the horse-drawn van that creates the duty. Yes, it is an act of a third party, the child who throws the stone, that causes the horses to bolt and causes the damage complained of, but the duty still attaches to the owners of the van for their servant leaving it unattended.
Well, the duty is to leave at the time of parking your vehicle, whether it's horse-drawn or motorised, to leave it safe, and that involves supervising the horse or putting the handbrake on. Yes,
we're taking the activity as a whole into account. But the point is that duty, in terms of that duty being owed to protect from the acts of a third party, which is the issue in this case. So again, it's not suggested here that the local authority left the poles on the highway. It's not suggested in Haynes and Harwood that but for the throwing of the stone by that child, the damage would have occurred. The issue is that the overall duty to conduct oneself safely when exercising that power cannot crystallize into a duty to protect from the actions of a third party, the throwing of the stone or the abandonment of poles in the market, unless that making things worse aspect occurs. And the function that making things worse aspect is in Haynes and Harwood, parking the van, leaving it unattended. In this case, it is the existence of the market, the responsibility for the market, the identification of the risk, and then not carrying out their own SOPs.
That's, on the way you're expressing it now, it seems to me that the only possible point of distinction that you're raising is the fact that by issuing licenses in your terms, they create a risk. Because otherwise it's exactly the same, well, at the moment, it's my view, provisionally, having not heard half your argument, that you're completely snookered by Ansell, East Suffolk, all of them.
And again, this is my reliance on the need to consider the activities taken as a whole. And again, I've not gone on to the authorities in that respect yet. But in my submission, But for that suggestion, and but for the points that are made in the cases about that, my lord would be absolutely right. The issue is that we do have those in the authorities, and it is those that I'm placing before the court, or will place before the court, to seek to make good that submission.
This has come back to the issuing of the licenses creates a duty.
But again, that's the issuing of that's taking the issuing of the licenses in isolation, whereas it's the issuing of the licenses and all that follows. Again, it's not simply said in the court below.
Sorry, what's all that follows?
All that follows is the manner in which the market has then been. So it's the existence of the market in the first place.
That's how the duty was exercised and whether there's a breach. Well, ultimately, your submission is there was a duty
Yes.
on the local authority.
Yes, my lady.
What do you say creates the duty?
Yes, and again, and if again, this is perhaps the point that will be more readily addressed when I take you to those authorities on looking at the entirety of the activities and make my submissions good in that regard.
But what do you say are the factors that
Yes.
crystallise a duty?
Yes, my lady. The responsibility for the existence of the market, combined, and this is all of a whole.
But that is through the licensing process.
Well, it's through the designation of the Market Street process, section 24. It's through the licensing process. Then it's the exercise of control and management over the market, which goes beyond mere regulatory or licensing. It's quite a high degree of control, as I will take you to in due course. The identification.
The exercising of control comes from.
It's the exercise of powers that are created under section 27, my lady.
Yes.
It's then that combined with the recognition of the foreseeable risks associated with this market activity in this location. The intent to mitigate those risks via the standard operating procedures that they require their market officers to comply with. And then the wrongful aspect is the failure to comply with those SOPs.
Right. So just interested in the factors that create the duty. Those the designation of the Market Street, the licensing, the statutory powers, the foreseeable risks, and the intent to mitigate via the SOP.
Yes, my lady, but I think there's a subtle distinction that's needed here, in that it's the creation of the duty for the omissions of the third party. Sorry, I beg your pardon. The creation of duties for an omission to protect against the activity of the third party. The duty itself, in terms of a duty that the claimant would need to, beg your pardon, that the appellant would need to uphold without the activities of a third party, is to take reasonable care so that none of its actions in the manner in which it regulates the market creates a danger or creates harm to a third party or to an individual. The subtle distinction here is that it is the leaving of the polls by the third party that requires us to go through these authorities in order to crystallize that duty. So there are two aspects to this duty. The duty on the local authority to take reasonable care in the exercise of its statutory power. That, again, could not require them to undertake an act, so that cannot impose omissions liability for the act of a third party. But it is that and all of the aspects that I've discussed when I take you through the authorities that creates the omissions liability point, if I can put it that way. Again, perhaps when I take you through my submissions in that regard, it may become more clear. The final aspect of the judgment. So again, we've looked through all of those findings that the judge made. At 174 of the paragraph 174, that's page 111. This is under the decision on the duty of care, the very final paragraph on the page. the judge below relies on the findings of fact that he's made to say that the defendant's in a situation as envisaged by 38 to 39 of Gorringe, and then goes on to say analogous of that, the defendant in Dorset Yacht, Phelps, Hillingdon, and Barrett and Enfield. Now, of course, Dorset Yacht, Phelps and Hillingdon, and Barrett and Enfield are three quite separate cases. We have one which relates to control over the third party, we have one which relates to the assumption of responsibility, and we have one which relates to, in essence, the professional duties that would be expected under Bolam of someone exercising special skill in any event. The analogous situation, or what the judge is looking at here, is readily understood when we turn to paragraph 38 in particular of Gorringe to see what is said there. That appears at 278 of the authorities bundle. And the particular relevant passage of this is in the centre of that bottom paragraph, paragraph 38. We are not concerned with cases in which public authorities have actually done acts or entered into relationships or undertaken responsibilities which give rise to the common duty of care. So the basis of the liability that the judge below found is that undertaking of acts that I've just discussed, when viewed as a whole, that give rise to the duty of care. In essence, the defendant here has done something positive when viewed as a whole in the licensing and regulations of the market, as we've just discussed. Similar to the defendant in Yetkin and Mahmood, which I don't wish to take you to, my learned friend opened that yesterday. And indeed, contrary to my learned friend's submissions, similar to the defendant local authority in Lisle, in placing a boardwalk on a right-of-way, not a highway for which they're responsible, but a right-of-way, without applying the requisite non-slip aspects to that boardwalk. It's all of a whole that the activity must be viewed.
The difference between this case and East Suffolk, where the council went into the flooded area and ineffectually failed to make it better.
In that they didn't make the situation worse, my lord, quite simply. Here, we say that the situation was made worse because but for the activity as a whole, so the licensing and existence of the market, the poles would not be present. The very existence of the market depends upon the actions of the local authority, whereas in the East Suffolk case, the hazard or the damage would have occurred in any event. Similar to that.
And your baseline is if they've done nothing at all. So
Yes, my lord.
unless you're basing the existence of a duty on the exercise of the power of giving licenses, from that moment on, if they'd done nothing at all, it would not have made matters any better, because the trader would have.
Indeed, my lord, and I think the issue here comes back to my point about having to look at the activities as a whole.
Thank you.
Again, and perhaps it's what Sir Anthony Clarke in X and Hounslow described as creating or increasing the danger to the claimant by those actions viewed as a whole. And again, we see similar wording used. I don't wish to take you to the judgment. If you do wish, I will. But Lord Reid in Robinson at paragraph 4, describing it in terms of the defendant having acted so as to create or increase the risk of harm. To turn to my Lord Justice Stuart-Smith's point about what would have happened if the defendant had done nothing, this is where I wish to take you back to those intervening Roman numerals in the Tyndall case, and they appear at paragraph 625. Sorry, I beg your pardon, page 625 of the authorities bond. The relevant ones, if I may ask the court to read from Roman 3 down to...
Oh, these are the ones you left out.
Yes, my lord, those, as I said, intervening Romans.
Yes.
Again, the first point, as my Lord Justice Stuart-Smith pointed out, the baseline is what would have happened if nothing was done. I will come to address that on the facts of the case in due course. Then at Roman 5, we have this other way of stating that general rule, being that the person owes a duty to take care not to expose others to unreasonable and reasonably foreseeable risks of physical harm created by that person's own conduct. Here we come on to the need to take that as a whole when we go to paragraph 45 of Tyndall, which is on the bottom of the same page. And if I can ask the court to read through that, please.
Paragraph what?
45, my lord.
Okay.
Yes.
And that again, my lords, is that example of the application of the handbrake that's drawn from Stoven and Weiss.
So is your argument that the baseline we have to consider is that there being no market there?
Yeah. There being no designated licensed street that would render market trading in that area unlawful.
So factually, there being no market there.
Yes, I suppose the reason I'm hesitant, my lady, is that it can't be entirely precluded that unlawful street trading would take place. It just makes it significantly less likely. And certainly significantly less likely that there would be cumbersome infrastructure such as poles and trolleys carted to and from a location through which street trading might take place.
Well, ultimately, you have to argue that the baseline would be
No
poles
market.
of that sort would not be there.
Quite right, my lady. Yes. In Robinson, a similar point is quoted from the speech of Lord Hoffman in Robinson. I beg your pardon. In Stoven and Weiss. Robinson is behind tab 17, and the paragraph I'm looking at appears at page 483.
483.
483.
This is where
It's
all
paragraph
these paragraphs
5.
go mad. or it's points made by Lord Hughes. Yes,
Yes, I'm looking at the bottom of that page at paragraph 5.
yes.
The argument that most cases can be equally analysed in terms of either act or omission, beginning there. And then if I could ask my lordships to read the quote from Lord Hoffman from Stoven and Wise that follows. I beg your pardon, my lordships and my ladies.
Yeah.
Again, the key point here is that the purpose of this act or omission distinction is, in the law of negligence, is to distinguish between, in Lord Hoffman's words, regulating the way an activity may be conducted. And I say that when you take that in light of the dicta in Tyndall that requires you to look at the activity as a whole, it's regulating how that activity as a whole is conducted and imposing an act or a duty to act upon a person who is not carrying out relevant activity. So again, the baseline, there could of course be no duty that would arise on the council to designate a street as a licensed street that they did not so designate. That simply couldn't happen, because you cannot, them not acting so as to designate a licensed street could not create a duty. However, once they designate the licensed street and engage on the activities thereafter, that is the activity that attracts the duty.
Sorry. Is it once they designate
A licensed street, by the way.
and
everything that followed, this is the conversations that we had previously had in relation to the licensing of the market traders. So it's not sufficient for them to designate a street under section 24. Designating a street without licensing traders would not result in the traders being there. Designating the street, licensing the traders, and then controlling and managing in quite strict terms the activities that take place on that street by the traders.
So if they designated the street and did absolutely nothing, there'd be no duty and no liability.
The point my learned friend made yesterday in relation to the construction of the statute, and this is why I rely upon the designation of the street point, is that it is quite clear that the wording used in section 27, that the licensing authority shall issue licenses if certain conditions are met, is that once the street is designated, there would be a potential public law challenge for them to unreasonably refuse a license to a trader who had met those criteria. But I don't say that's relevant for the purposes.
Sorry, I perhaps worded it wrongly. So if they designate a street, grant licenses, but do nothing, they don't put any system in place, they don't have a SOP, then that is not sufficient to create a duty. Or is it the designation creates a duty?
The designation would bring with it the foreseeability of the harm. I would have to accept that if there was no further action taken place, they simply designated the street, issued the licenses, and then said, hands off, we're not going to control what you do, a duty of care could not arise. This is why it's the activities as a whole of the market trade, of the market licensing authority. They didn't do that.
So by putting a SOP in place and taking some measures, they create a duty where otherwise none would exist.
Well, the additional factor, my lady, is by putting the SOP in place and then not carrying out the letter of the law, that's all.
So there's an obvious concern there that a local authority who does nothing is in a better position than one who puts a SOP in place.
Yes, my lady, but that would be the sort of public policy reasons for not imposing a duty that have been moved away from and most recently said in Tyndall. The facts are here that there is a activity when seen as a whole that meets the criteria for the creation of an omissions duty under the established authorities as I've gone through, and therefore it follows that that duty should be created.
I think this is quite difficult. Suppose they license the area and they designate the area and they license traders, say 50 traders, doesn't matter how many, and then do nothing else at all. They never inspect, never look to see whether there are pearls lying around or anything like that. That's pure omission.
Yes, my lord.
I think you accept they can't be liable in negligence.
Not in negligence, my lord, no.
Nor in nuisance.
No. But this, my lord, is why the respondent's case has not simply been the licensing simpliciter of the market. It has been the licensing and the manner in which that licensing and management has been undertaken. There is clearly a recognition, and again I'll come to the evidence for this, of the foreseeability of these hazards, and there is clearly an active attempt to mitigate the risk of those hazards. They chose to impose the SOPs that they did upon their employees, and then, as I will take you to, said we don't actually need to have a late officer on 2 days a week. So while we originally identified that this was the standard we must meet, we're not going to meet that standard. And it's that issue. It's the knowing identification of the risk, identification of the appropriate measures to mitigate that risk, and then not taking them. That is the activity as a whole that creates the duty here.
So they've created their own duty through the SOP.
Yes, my lady. I beg your pardon, my lady. They've created the means to identify, they have identified what would be appropriate measures to fulfill that duty.
So the identification of the measures creates the duty.
Yes, my lady.
I think I must have noted this down wrongly, because if I've noted it down rightly, you've said two different things in the space of about 30 seconds. So can I just tell you what I've got?
Yes, my lord.
The activity, for which I would say the act in normal legal parlance, that attracts the duty is designating the license, street, and starting to give licenses. Because you submitted at one point, it's foreseeable that traders will not comply with license terms. Therefore, the giving of a license has given rise to a risk of injury, and you say that's a positive act by Tower Hamlets.
I'm sure the fault's entirely mine, my lord, in terms of clarity, but that's certainly not what I had intended.
I've got the opposite in my notes, so worth clarifying.
Yes.
So, but then you went on to accept that if they gave licenses and then did nothing, duty could not arise from that omission to act.
My lord, I completely understand the
From
confusion.
which I understand that if you had a situation where the council had designated the licensed street, issued licenses, and then done nothing, there would not be a duty, a private law duty.
Yes, my lord, I did say that, and I stand by that. In terms of the first aspect of the
Yes.
note,
What should I have written down?
my point was that it was the designation, the licensing, the control of the market, through the control and management of the market, the SOPs, the identification of the foreseeable risk, and then the failure to comply with the SOPs. That's it's the activity taken as a whole point, my lord, that attracts the duty.
But the creation, if you take that in stages,
Yes, my lord.
so you've got licensed traders and accept for the sake of argument that it is foreseeable that some will not comply with their licence conditions. If they all comply with their licence conditions quite beautifully, as one might wish in Whitechapel Road, then there's not a problem. But if there's a foreseeable risk, okay? At that point, just stopping the clock there, no duty.
No.
No duty. Or no, you're wrong. Stuart-Smith, LJ.
No, I beg your pardon, my lord. No duty.
Right.
Again, it's my submission on the need to take these things as a whole. So taking things in isolation, licensing the market simpliciter, not a duty. Designation of a market street simpliciter without anything further, not a duty. It's when all of those things come together in the manner that they have here, including the recognition of these risks, the implementation of the SOPs to address these risks, and then the failure to adhere to those SOPs, that's the creation of this duty. If I could
Surely, what you're really saying is the steps that they've taken are ineffectual to remove the risk of injury.
No, my lord, because I would say the steps that they've taken, or the steps that they've identified as needing to be taken, or had taken, or may have taken at one point, are evidenced by the SOPs, which list all of the times at which inspections will take place, and list all of the things that need to be inspected for. And I do intend to take you to the SOPs and to make that good, that submission. The issue is they failed to adhere to those SOPs. So they have identified.
But that involves submitting that simply creating the SOPs means that they are then under a duty to comply with them. A private law duty to the claimant to comply with them.
Creating the SOPs in the circumstances of taking the activity as a whole, my lord. And again,
That's the moment on your argument that the duty arises, because no duty if they'd simply designated the street, issued licenses. It's the creation of the SOP, which involves an assessment of the risks, that creates the duty.
And coupled with that, the failure to fulfil that standard operating procedure.
That's
And again, this is talking about the duty. Well, again, in the same way that the abandonment of the horse-drawn van in a public place is the breach, but also the wrongfulness.
It's not analogous for two reasons. One, it's not factually analogous. We can argue about that. Or at least I won't argue, but we can discuss that. And secondly, it's not talking about conduct pursuant to a power, statutory power, which underpins everything in this case.
It does, my lord, but again, Robinson, Poole, Tyndall, it's made abundantly clear that where an ordinary person who's not a local authority, or not a statutory authority, in those circumstances could be subject to a duty, the same circumstances would apply to a local authority. If normal principles of negligence, and I say that's where we are, would apply a duty of care in these circumstances, then the source of the powers that are exercised is not relevant. The factual analogy between Haynes and Harwood, again, as I said, well, we can perhaps discuss, but I wonder how far it will take us.
I just don't see that we can run existence of duty and breach of duty together. In order to determine whether there's been a breach of duty, one needs to be clear about what the duty is, where it's arisen from.
Yes, my lady, if I could think about that for a moment.
You can come back to it.
Yes, I think perhaps that might be sensible to come back to that in due course.
I mean, this is just basic principles. We start with duty, then we look at breach,
Well,
then we look
quite
at
well.
causation.
Quite, my lady, but again, as I say, I draw that analogy between the Haynes and Harwood case and the example given in Tyndall, which I rely on to say that that wrongful act can be both the breach and the wrongful act that creates the duty for omissions liability, and that's the distinction.
Does it come to this? That your submission is that if this market area was run not by Tower Hamlets pursuant to a statutory power, but by a private, I was going to say landlord, but by a private enterprise.
I think the difficulty in the analogy in this case is that it would be difficult to think of circumstances in which a private entity would be empowered to license a market on the public highway. A private entity running a market is likely to do so on private property that they have a lease or a license or some sort of interest in. And that's a slightly different relationship because they then become occupiers, and we'd be talking about slightly different things. The issue here is that public highway aspect, because Whitechapel Market is, while we've been referring to it colloquially as Whitechapel Market, it is a series of market stalls that are licensed on the public highway in Whitechapel. And I'm sure it's my failing, but I've not been able to come up with an analogy of a private law, or I beg your pardon, a private entity being able to do so.
Well, you said, threatened, you were going to take us to the detailed provisions of stop, but before you do that, I don't see why they're relevant. I'm just seeing this at a very simple level. Your factual complaint is that sometime that afternoon, probably, a trader dismantled his or her stall, left the poles lying there. At 5 o'clock, your client falls over them. And the council was supposed to have officers on duty, 3 shifts broadly, the last one starting at 2:45, continuing till 6 o'clock, by which time I imagine on a December day there's nobody there. And for whatever reason, there was no late officer on duty that day. We don't know whether, if there had been, the officer would have seen the poles. We don't know why there wasn't a late officer on duty, but ordinary knowledge of life might be that short of staff, somebody didn't turn up, the budget was tight, the least busy time of the 3 shifts is the last one. We had nobody in the last one. Why should it be any different from if there had been no provisions for officers in shifts, or that the provisions had been that there should be 1 officer there in the mornings and that's it? Why should that make any difference to the question of whether the council is liable either in negligence or in nuisance? I don't follow.
In the first instance, we do know why the markets officer was not there, and I will take the court to that in due course. As I had alluded to earlier, the evidence before the court below was that on at least 2 days a week there would not be a late markets officer in presence due to staffing and deployment of resources elsewhere. Why is that relevant? Is because the reason to take you to the standard operating procedures is that there are a number of time slots in respect of activities that must be undertaken that on that document are expressly referred to as being subject to staff availability.
Yes.
The one between 2:45, I beg your pardon, 4 o'clock and 6 o'clock in the evening, which would extend the 2:45 aspect, is not one of those. It is one that the standard operating procedures that the council themselves have put in place recognise on the face of the document should happen on a daily basis. And again, it is the minimum activity that is needed to mitigate the foreseeable risks of harm, again, which I can take you to. The other aspect, my lord, about the busyness of the morning period, the evidence below is aspects of the busyness of the morning period related to the collection of revenues, etc., and the allocation of stalls. In my submission, in respect of the risks and hazards that could be created, both the morning shift and the late shift would be equally hazardous, if I can put it that way, because they are either erecting the stalls in the morning, thereby things lying around, or they are collapsing the stalls in the evening. The least hazardous shifts would be those in the middle of the day.
Or maybe, or change that again, suppose there's no provision for any inspections at all.
Well, again, no provision for any inspections at all creates an issue, because it's the exercise of the powers and control over the market traders, the recognition via the SOPs of what needs to be done, and then the failure to do that, in my submission, that creates this issue.
Okay, right, let's move on.
My next topic was going to be the existence of the market, but we've discussed section 24, section 23, etc. In quite some detail, and I don't propose to dwell on that unless I would assist the bench further. The next point is this foreseeable risk of harm that is brought with the existence of the market. Again, this is a market on a public highway that brings with it the risk that the activities of the market traders may create hazards or obstructions on the highway. As I referred to earlier, my Lord Justice Bean had said that is common sense, but I don't need to rely on common sense. Specifically, if I can turn to page 128 of the core bundle. This is paragraph 244, I beg your pardon, it's 127, paragraph 244 of the judgment below.
Sorry.
Paragraph 244, my lord, page 127.
Okay.
Here the court below recognises there is a known issue with market traders abandoning equipment unattended and difficulties in keeping the market tidy and clean, and he refers to the live evidence of, I beg your pardon, the witness statement of Mr. Patchell in support of that. The next document is referred to over the page at paragraph 245, and this is the Whitechapel Market Action Plan, to which I will take you in due course. This was a document that was before the court and considered by the court, and it sets out, and perhaps I will take you there, it's at the supplementary bundle at 198. In essence here, since at least 2016, there was a known issue with, among other things, excess waste and market structures left on site during and after trading hours, and a lack of throughways between and behind stalls for trader and pedestrian safety. Those are the 4th and 5th bullet points down on that page under the heading Challenges.
Sorry, what page?
Beg your pardon, my lady. Page 198.
I was just trying to see where this was referenced in the judgment.
Yes, my lady. Paragraph 245. The last sentence, both low lighting and excess waste were risks that the defendant has identified within their own action plan for the market. In the same action plan, over the page, again, the previous challenges were identified as of 2016. Over the page, it makes it clear that as of 2021, now that is after the claimant's accident in this case, but I will make the point that I am. But in 2021, there were still identified or confirmed challenges, including stock cages littering the pavement, phone boxes being used for storage during trading hours, poor visibility for pedestrians crossing the road, and accessing bus stops. 2 are hidden from view during market hours. And that is the 4th and 5th bullet points down. And the point here is that since at least 2016, the market were aware of these persistent issues within it, and that persisted up to at least 2021. So there is this foreseeability of harm in my submission. The point is made further in respect of the Levelling Up Fund. This is referred to at paragraph 246 of the judgment below, and appears in the supplementary bundle at page 176.
136.
176, my lord.
I'm so sorry.
Here I'm referring to the paragraph at the top of that page, second sentence beginning, the market's informal appearance creates a perception of untidiness in the civic part of the borough and acts as a barrier to movement. The current configuration impedes road crossing, access to and from bus stops, and lacks storage, waste management and toilet facilities for traders, limiting the potential for existing retailers to expand, etc. So the key points there are the acknowledged impeding of road crossings, access to and from bus stops, etc., and the issues that creates. Returning very briefly to the points I made on nuisance yesterday, and the points from Sedley Denfield in relation to knowledge or means of knowledge. This, in my submission, forms the first factual plank of that knowledge. There was a known problem in the market area with abandoned materials. The second plank of that comes in relation to the control of the market through the standard operating procedures, to which I will turn now.
Are you going to go back to Sedley Denfield? Or
I wasn't intending to.
you just said known problem, known source of danger.
Yes,
Of course, if the council actually knew about these pearls, then you'd probably be home and dry.
yes, Lord.
But knowledge of the problem as a whole seems to me more difficult.
This, my lord, is why I said this is the first plank of the knowledge aspect.
Yes.
The first,
Knowledge, it could be said that any poorly lit and cluttered area is a dangerous place to be walking on a December night. what are the council supposed to do about it? Not the occupier.
No, my lord, that's right. This comes back to the point that I made on the basis of L.E. Jones, in that, while not the occupier, they do have sufficient control over the source of the hazards. Now, to go back to the first point that you made, my lord, about the knowledge point, I fully accept that this general knowledge of a general problem in the area could not be sufficient in and of itself to get across the line for the knowledge requirement in Sedley Denfield. Something further is required. And I say that something further relates to why I brought you to the passages relating to the defendant having the knowledge or the means of knowledge of the source of danger. And in this case, when I take you through the standard operating procedures, I say that those being complied with correctly create the means of knowledge, coupled with the existence of the general knowledge about that risk, taken together with SOPs to try and address that or to try and be aware of it. That is the constructive knowledge that is imputed to the defendant.
Right.
Thank you, my lord.
That was the first plank.
That was the first plank. The second plank, my lord, it comes from the standard operating procedures. I beg your pardon, yes, which will come in due course. My lord, I had intended next to take you to the license conditions, but the point is a simple one, and we've been here yesterday. This is in relation to the degree of control exercised through those conditions. It's not simply licensing. As has been pointed out, there are conditions in there relating to the need to comply with health and safety, relating to the waste management within the area, which is the responsibility of the defendant, the location and size of the pitches, which is at condition 13.1. I'm more than happy to take the court to all of these if they feel it would be of assistance, but I'm in your hands in that regard.
It's a submission. I mean, we've looked at the conditions.
The submission is the level of control. More importantly, for my purposes, is the standard operating procedures, my lord.
Well, do you say that the level of control created by the license conditions is ample, sufficient?
Well, I say it exceeds that which would be simple licensing or regulation of street trading. It goes to control and management of the trading in the area. This is not simply I'm licensing you to go to that part of the street and sell your wares. It's you are doing it in this very prescriptive set of conditions. You must do this, you must not do that. There is the point that I'll come to in respect of ground 3 about the power to remove, but we've been there yesterday and I don't see a necessity to cover that yet.
So you're going to the SOP.
Yes, my lord. The standard operating procedures appear in the core bundle. I beg your pardon, they don't. They appear in the supplementary bundle. I'm so sorry. They begin at page 123. And the first point to make is the point that I alluded to earlier. When we look at that first shift on Monday morning, the markets officer on site from 8:30 or as close to that time as possible. That is not qualified by the suggestion that that is subject to staffing, nor is the shift indicated at 8 AM to 9 AM. The first one that is qualified by that phrase in parentheses is on page 125, and it's the officer on site from 9 AM to 10:40 AM. You'll see in brackets after that, depending on staffing levels and availability.
Are you right about that? Page 124.
125, my lord.
Yes, but 124, first black bullet, officer 2, depending on staffing levels and availability.
I beg your pardon, Moira. Quite right. Quite right. I have missed that one. The point remains that for a second officer to be there, for an officer to be there between 8 and 9, is expressly acknowledged in these standard operating procedures to be subject to staffing levels and availability. I say that's entirely reasonable and appropriate because in conducting that, one would assume the local authority have conducted some sort of risk assessment and identified that these shifts, for whatever reason, do not carry the same risk, and therefore staffing at that level, it would be entirely open to them to decide that that's subject to availability. The problem is that the shift in question in this case, which appears at page 129, the officers on site from 1445 to 1800 is not so qualified.
But in the morning, there's officers have to be careful to ensure that people who set up stalls are entitled to be there. There might be a fight as to who's entitled to a particular pitch. There's all sorts of things going on in the day. Why does this help us?
It helps us, my lord, in that I would be in much greater difficulty making this submission if that late shift was expressly stated in the SOPs to be subject to staff availability or dependent upon staff availability. They would have therefore acknowledged that we don't have to have someone on this occasion. But on the face of the document as it stands, that's not a qualification that's been imported. As I said earlier, yes, I would have to accept that in the morning at setup there is the collection of revenue, the designation of market pitches, the potential resolution of conflict between market traders about who's getting what pitch. There's also the hazards that come with the setting up of market stalls. Those first three aspects, the disputes, the revenue, the designation, don't arise in the afternoon, but that fourth one does, in reverse, if I can put it that way. The hazard in the morning is created by the erection of the stalls. The hazard in the afternoon is potentially created by the collapsing of those stalls afterwards.
You say you'd be in perhaps greater difficulty. In fact, you couldn't maintain the argument as you've advanced it if it did say subject to availability, which means that effectively what you're saying is the SOP is what creates the duty.
Yes, my lady, I think that must be right.
Or possibly you could refine it down a fraction by saying the SOP defines the scope and extent of the duty.
Yes, I'm grateful, my lord. And I think that is the point I think I had previously made in response to that. It identifies what is necessary to fulfil or discharge that duty.
But then, as my lady said a while ago, you run straight into the problem of, well, what would have been the implication if they hadn't had a SOP?
And as I said to my lady in response to that point, this is squarely within. It may be argued in a case like that, and I'm not arguing it here. It may be argued in a case like that there needs to be some sort of incremental reasoning by analogy, as is set out in Tyndall, Robinson, etc., in order to try and seek to expand existing duties. I'm not saying that here because I'm not saying that's necessary, because the SOPs were there. And again, that expansion of the duty, while public policy may come into the question of whether it should be expanded, it's not something that will be definitive post Robinson, Tyndall, etc. Going through the requirements of the officers on those shifts, perhaps it's most relevant simply to go straight to the afternoon shift that was missed, and this is page 129.
Well, we've looked at this, and there's the fifth one is ensure ongoing compliance of licence conditions contained of waste and so on, and the seventh is to ensure all ... walkways are clear of obstructions.
What I have all social space, bus stops, crossing and walkways are clear of obstructions, and social space is precisely what the judge below found the gap between the market stalls where this incident took place is. This was, as my lords and my lady will recall from the photograph you were taken to by my learned friend, an area where there was a bench, a litter bin, and a number of tree stumps upon which people, one of my lordships indicated, tend to sit. This falls squarely within the requirement to be an area that the market trader should ensure is kept free of an obstacle. These SOPs, my lord, if being complied with, are the means by which the specific knowledge of the hazard in question on the day in question would have come to the attention of the defendant. Not being complied with does not mean that you cannot then impute knowledge. They had the means, had the SOPs been complied with, and therefore I say should be found to have continued the nuisance.
The final bullet point is to report contraventions as necessary using the form provided.
Yes, my lady.
So if there'd been an inspection at some point during this period, what would the duty have been if the poles had been seen?
Yes, and at the hearing below, evidence was led on this in respect of what the market manager, Mr. Patchell, and indeed one of the other market employees, Mr. Uddin, said would have happened, and in essence there would have been attempts made to remove the poles
Straight away.
As soon as practical.
And was there any evidence on what that meant?
If I may turn my back briefly, my lady.
Is it covered in the judgment somewhere?
Yeah.
In the judgment?
If I may briefly, my lady, let me just consider. My lady, is that a point I can come back to you on after the luncheon adjournment? Those my lordships, my ladyship, is the SOPs. The short submission is that the judge below found that the defendant did not adhere to those SOPs, as I've already discussed. That is at paragraph 276 of the judgment below. The core bundle, page 134. In terms of the reasons for the absence of a market officer on that day, Mr. Patchell's evidence, of which you have a transcript at the hearing below, this appears in the supplementary bundle at 311.
We don't have to show us extracts from the transcript to support a finding of fact, particularly where it's said that it was agreed.
Well, this is the reason why it occurred, my lord. And Mr. Patchell, in essence, says that it was staffing levels at the time. There was an individual who was on reasonable adjustments, etc. And the culmination of his evidence in that regard was that there would be 2 occasions per week on which Whitechapel Market would not have a markets officer on site in that afternoon shift. So again, this is not an isolated feature or an isolated incident. This is a function of how they were conducting the market, and goes to my point about this overall management of the market, identifying what needs to be done, and then accepting we're actually not going to do it for whatever reasons.
Right. What's the next topic?
The next topic, my lord, we have been through. It's the Mitchell objection, as I have phrased it. One of the lesser known Robert Ludlum novels, I believe. It essentially will be said against me that it's this wrongful act point, and this derives from Lord Roger and Lady Hale's speeches in Mitchell and Glasgow. I've made the point about this already. I say that it's not merely the exercise of the appellant's statutory powers that's the activity that attracts the duty in this case. It is the overarching looking at the activities as a whole, and that degree of wrongfulness, if it is necessary to create that omissions duty, arises by that failure to comply with the SOPs that were identified. Again, I reason by analogy to Haynes and Harwood. I reason by analogy to the example of the car being parked at the top of the hill with the handbrake left off. We have covered that, and unless my lordships wanted to engage in that any further, I don't propose to dwell much longer on it.
No.
Well, it's that those are essentially the submissions on the making things worse aspect. Unless I can assist further in that regard, I would briefly turn to sufficient control of a third party. I can take this relatively shortly. In essence, the primary and main submission that we make is that this was a making things worse case for the reasons that I've set out. While Tyndall does, while Lords Legate and Lord Burroughs and Tyndall do doubt whether or not something other than quasi-parental control could attract a duty of care to take care of another. It is not in my submission. It is obiter. It's not in my submission binding. However, I don't seek to produce any authorities before you to say that it could be anything other than parental control, and I don't propose to engage in that any further.
So no authorities that it applies in a relationship other than parental control. What about Dorset Yacht?
I beg your pardon, quasi-parental, so the special high level of quasi-parental control.
Special high level.
Yes.
And do you contend that the control that the council either did exert or could have exerted is analogous to the position in Dorset Yacht?
I think on the authorities, my lord, I'd have difficulty in making good that submission. These are not Borstal Boy
I take that as a no.
prisoners. However, if I may, very briefly, Dorset Yacht, throughout the authorities, as you've seen, has been, for instance, it's been considered as, I beg your pardon, oh my God, It's been considered, as my learned friend indicates, under a number of heads of sort of classification, if I can put it that way. There's the special level of control aspect, but in other cases it is understood through that window of making things worse, as we would say, post Robinson understanding. It's often cited alongside the Attorney General of the British Virgin Islands and Hartwell in that respect, and that is the case where
shooting.
the probation or police officer is given a weapon despite them knowing that he had, I think, unstable mental health at the time. That, my lord, could be seen to be a slightly lower level of control than that parental borstal aspect, in that it's more akin to the management or employment relationship. But I don't take it any further than that in my submissions in that regard. I think given that that's a Privy Council decision, given it's not before the court, it would be difficult for me to make that good. And I rely primarily on the making things worse submissions in respect of negligence that I have made.
You don't rely on sufficient control of the third party.
I don't really. My lords, my lady, that completes ground one, unless there's anything else with which I can be of assistance.
No, thank you very much.
It will no doubt be a relief to all to hear that ground 2, 3 and 4 should not take nearly as long.
No, well, they didn't get Mr. Hedgeman on. But,
Turning to ground 2, in
yes.
my submission, this ground, my lords, it's a challenge to a finding of pure fact. There is a high bar from the authorities that must be met before an appeal court should consider interfering with such findings of fact, and I say that bar is not met here. In support of that submission, if I may first ask the court to turn to tab 16 of the authorities bundle. This is DB.
I'm afraid I'm just reminding myself of ground 2.
the DDJ was wrong to find the pearls have been left on the highway since 1445. Tell us, before you take us to an authority, tell us what the authority is going to say, because it may be that we're intimately familiar with it.
Indeed, my lord. It's the authority of Lord Justice or Lord Kerr in the Supreme Court. In essence, he is here saying that just because the finding of fact at first instance doesn't necessarily relate to oral evidence and may be based on analysis of documentary evidence, does not mean that such caution should not be exercised in an appeal court overturning the aspect. His rationale is that at first instance the judgment provides a template on which criticisms are focused. The assessment of factual issues by an appellate court can be a very different exercise in the appeal setting than during the trial. Impressions formed by a judge approaching the matter for the first time may be more reliable than a concentration on the inevitable attack on the validity of conclusions that he or she has reached, which is a feature of an appeal founded on challenge to factual findings. The case for reticence on the part of the appellate court, while perhaps not as strong in a case where no oral evidence has been given, remains cogent. In the present appeal, and he goes on to give his views on the present appeal, that appears at paragraph 80.
Yes, well, so, the last 3 paragraphs of that judgment are pretty familiar.
Yes, my lord. Equally familiar, I'm sure, will be the decision in Volpe and Volpe.
Lord Justice Lewis and island hopping, yep, we know that.
Yes, my lord.
I don't think there's really any dispute about the principles. We need to look at what the judge actually found,
Yes, my lady.
whether they're findings of fact or whether they're inferences that he drew from his primary findings of fact, which are more amenable to challenge on appeal.
Yes, my lady. In that case, if I could turn to the judgment below at page 129 of the core bundle. And paragraph 257. Here, the judge accepts he is insufficient evidence to determine precisely when the trolleys and the scaffolding pole appeared in the location of the accident, but takes account of the following. The standard operating procedures which we have referred to, and the shift that should have taken place. He, in essence, in 257.2 on the subparagraphs, rejects as relevant Mr. Patchell's evidence that he did not see the poles on the day in question for the reasons set out thereunder. And these are the matters that the judge explicitly lists in his judgment that were taken into account. However, at paragraph 258, the judge says, in reaching a conclusion as to when the scaffolding poles / trolley were in place at the location of the accident, I've taken into account all of the evidence, specifically that set out at paragraph 257 and the paragraphs above. Now, pausing there in terms of all of the evidence that was available to him, that included the live evidence of Mr. Udden and Mr. Patchell, including, as he refers to at paragraph 275.5, I beg your pardon, that should be 57.5, Mr. Patchell's acceptance in cross-examination when the photographs of the trolley were put to him, that they had been there for some time, albeit Mr. Patchell could not say whether that was hours, days, etc.
On what basis could he say that they'd been there for some time? I mean, it's a good
Viewing
answer
the
to getting
photographs
cross-examination, but what?
Viewing the photographs as someone who is used to the state of the market and what these trolleys.
It's impossible. That's completely impossible. You see a photograph of taken at 5 o'clock on the 19th of or whatever date it was. You look at it. What features of that photograph can possibly indicate how long the material had been there?
This is my next point, my lord, in terms of the other materials that was before the judge at first instance, and they were those
Okay, I've
photographs.
jumped the gun. What are the materials?
This is core bundle at 158 to 161. I beg your pardon, supplementary bundle at 158 to 158, I say, is not a relevant photograph, and I do not draw the attention to it. 159 is not helpful. 160, however, is, and this is a photograph that was included in Mr. Hedman's skeleton argument. It is the disposition of the poles where they are left beside a rubbish bin with rubbish accumulating around them. It is the manner in which there is cardboard lying against the side of them, the manner in which the tarpaulin is draped haphazardly over those.
This is all leading to the conclusion that they were there for two and a quarter hours, not days or weeks or anything of that sort.
At least 2.25 hours, my lady, is the finding the judge made. And I say that finding was open on his analysis of all of the evidence, including these photographs, including
How
everything
did
that
the
you
photograph get to at least 2.25 hours?
looking at the disposition of the poles, looking at those aspects of where
What
they
is
were
it
found.
about? I'm sorry, you're not getting away with that. What is it about the condition of the poles?
It's the manner in which they are left where they are beside a litter bin, and this is a point that the judge explicitly makes about the them being left in the proximity of a litter bin, and I'll take you to that part of the judgment.
But hang on, if you look at 160, okay, you've got a litter bin.
Yes.
You've got a see-through, just to the right of it, a see-through plastic bag full of things like cups. Not
Yes.
indicative of how long they've been there, could have been put there 5 minutes before.
Yes, ma'am.
You've then got round to the left, you've got a flap of cardboard,
Yes.
which isn't disintegrating. It's just, as far as one can see, it's just sitting there. Surely that is also consistent with having been placed there either 10 minutes or 3 hours or any length of time, but not days or weeks.
I understand the point, my lord. The point I'm making is that it was the judge below's viewing of all of the evidence as a whole, and the points to which I come to next. These are all things that build into what he took into account.
But the appellant says these do not add up to anything. And therefore, what we need to understand, if there is evidence on the basis of which the judge could reasonably have formed the view, then we'll uphold it. But at the moment, you're saying, have a look at these photographs. And I am rather uncharitably challenging you with the suggestion that these photographs do not show anything about the duration for how long the poles have been there.
And I would say, taken in isolation, they don't. In the same way that taken in isolation, not one single piece of evidence would lead to that. But it is the judge, in accordance with those principles set out in Volpe's overall analysis of the evidence, having sat through the 2 days of the hearing.
But I'm sorry, I'm going to press you once more. It's all very well saying he took all the evidence in concern, but this is one of the pieces of evidence which is said to contribute to a finding. And at the moment, speaking entirely for myself, I can't see anything in these photographs, which I assume are in the same condition as the judge below had,
Yes,
which gives any indication at all that the poles have been there for any particular length of time.
Well, in relation to the specific photographs, I don't think I can.
But if you've got some better photographs, we'll look at them.
No, my lord.
But also the judge has taken care to set out in a series of sub-numbered paragraphs those factors that he has specifically taken into account. Now, yes, he says, I take account of all the evidence, but if there was some vital piece that was the missing piece in the jigsaw, he could properly be taken to set that out in one of his sub-numbered paragraphs.
He could, my lady, but again, as Volpe and Volpe makes clear, it's not necessary to analyse, as one would a contract or a statutory provision, the wording of a specific judgment. It's made clear in the authorities that it's always the case that judgments could be better worded or more felicitously worded.
Of course, but one has to look at how he's reached his conclusion, and if he set out his workings, as it were,
yes, my lady,
and they don't add up to what he says they add up to, then we're entitled to look at that.
Well, I say that the comment by the judge that he has taken into account all of the other evidence opens it to make reference to those documents, also to the Whitechapel Market Action Plan and the established history in this area of items being left lying around. Similarly, the levelling up from persistent difficulties in this area in relation to that. And I say, when taken as a whole, the judge was entitled to make these findings, and my lord and my ladyship should be hesitant or reluctant to disturb those findings. I don't think there's much more I can say on ground two.
Ground three.
Ground three. This has been largely foreshadowed and canvassed, so hopefully it can be taken relatively quickly. In short, turning first to the section 35 point, the interpretation of cessation of trading that was suggested by my Lord Justice Stuart-Smith yesterday is, I say, the one to be preferred. As a reminder, section 35 creates the power by which materials, receptacles, can be removed from the market to a place of storage on the cessation of trading if they've been left lying around. Again, I say that the interpretation that was put forward by my Lord Justice Stuart-Smith yesterday in that regard is sensible, and indeed to say that it would have to be the cessation of all trading in the market, as my Lord Justice Lord Bean said yesterday, would be somewhat nonsensical and would not address the, to quote my Lord Justice Stuart-Smith, the vice at which this provision is aimed, and that is essentially to prevent stuff being left around the market and creating a hazard, as this particular item did. So my primary submission is that section 35 in this instance did create a power of removal. It could not be said that trading had not ceased in respect of this particular market stall. The poles were sitting on a trolley the tarpaulin was draped over it and the trader was nowhere to be seen. Clearly, trading had ceased in respect of that particular stall, and so a power arose under Section 35 to remove it. I've made the points about the conditions. I understand from the response from my Lord Justice Stuart-Smith yesterday, you're not entirely with me on the interpretation of Section 17.2 and the ability to seize items. However, I reiterate those submissions if I'm wrong on the Section 35 point. And on that basis, I say that is sufficient for the court to dismiss ground 3, unless there's anything else that I can assist with in that regard.
I think ground 3 is really about the time that there should have been an inspection at that time, and that therefore defendant should have identified. But also we come back to this factual point about what the defendant should have done if there'd been an inspection.
Well, yes, and again, if there had been an inspection, and that's perhaps something I need to come back after lunch in terms of the time that it would have taken to remove it, but the evidence below that I can take the court to was, had this been identified, it would have been removed.
The judge addresses causation extremely briefly and doesn't really engage in an analysis of factual causation in the judgment.
And that is ground 4, to which I will turn if the court is satisfied with ground 3. Perhaps, I beg your pardon, I've perhaps overtaken myself somewhat to finish the point in respect of ground 3.
My fault, sorry.
No, not at all, my lady. Yes, the interpretation of the appellant's powers that they could have been removed prior to the cessation of trading is addressed at paragraph 84 of the judgment below, which appears at page 93 of the core bundle. No, I beg your pardon, of giving you the wrong reference. Beg your pardon, it's paragraphs 84 to 93, and that appears at page 86 of the bundle.
Mr. Uden's evidence.
Well, it begins, I accept, Mr. Uden's evidence, which he confirmed. This is the market officer attending to the in short, the trolley being lying around would be reported to the trader in the first instance, who would remove it. If it was not possible for the market officer to identify which trader a piece of equipment would belong to, he would arrange for it to be removed and placed in storage. The equipment would only then be returned to the trader when he or she came forward, following payment of a fixed penalty fine. Officers do not generally interfere with the traders whilst they are erecting their stalls at the start of the day, or when they are dismantling them at the end.
Totally sorry, I haven't got the right page.
I'm so sorry, my lady. Page 86 on to 87.
Right, thank you.
Paragraph 85. Yes.
Thank you.
On the next page is 87, at paragraph 89. This is the evidence from Mr. Patchell.
Yeah. And you refer to paragraph 20 at the bottom.
Yes.
Paragraph 87 is a problem, isn't it? That the duties all based around what
Well,
the defendant identified as.
There was an inconsistency in that regard, in that, and again, we can go to the transcript in this regard. You have initially Mr. Uden saying, the quoted paragraph 85, that action wouldn't necessarily be taken. That it would be the initial action would be to report it to the trader and ask them to remove it, and then if it was not possible, the market trader would do it.
Yeah.
And then there's that somewhat contradictory aspect that becomes resolved, I say, in Mr. Patchell's evidence, which is quoted in 89.
So
For
this
example-
reading suggests wouldn't generally be moved until after 7, and then
Well, it's Mr. Patchell, and it's, for example, begins halfway down. This could be a trader who was storing his stock following dismantling of a stall on the relevant day and would arrange for the trader to remove it immediately.
but no one can identify who the trader is here.
Exactly, my lady. And that falls into to the earlier,
So it's paragraph 20.
yes.
I'm just looking at your skeleton argument. It may be that you've actually covered the ground. As
May well be, my lord. I think there's little more than is set out in my skeleton argument in that regard that I would have to say in respect of ground 3.
yes,
If my lord is content with that, I will move to ground 4.
yes.
Again, as I had foreshadowed with my reference to Ellie Jones, there is 2 tracks of causation, in essence, in my submission in this case. The first is the negligence track, and the second, which I say is slightly easier for the respondent, is the nuisance track, and I will address those in turn. In respect to the negligence,
Can you crank up the volume, please?
I'm so sorry, my lord. The 2 the 2 tracks of causation, if I may put it that way, in this case, on the basis of Ellie Jones and paragraph 23 of that decision, are the nuisance track, which I say is slightly easier for the respondent, and the negligence track. And I will address negligence first, and then come on to nuisance in respect of ground 4. Again, we've seen that the trial judge has found, as a matter of fact, that the poles had been at the locus of the accident since at least 1445, and the trial judge then commented that he considered it highly likely that the poles had been there much longer. Then went on to find that the appellant should have ensured an inspection of the marketplace took place at the relevant intervals, and then noted that following the respondent's accident in particular, this is at page 257, or paragraph 257, page 135 of the core bundle. It's 275 and it's 134 of the bundle. As I had pointed out in the submissions, he makes reference to the fact that there was no urgency in the removal of the scaffolding poles or trolleys after the injured claimant, after the claimant was injured, and Miss Gohan, whose evidence was read in court, was that 15 minutes after the accident, nothing had been removed. Mr. Patchell, in live evidence, indicated that the accident in question had not been reported on the day in question, and as the market area manager, the awareness there was not until quite some time after the accident happened, but on the day in question, it wasn't reported. So the simple submission is there was no markets officer on that afternoon. In no way could a markets officer have inspected the area, given this was as has been noted throughout this appeal, December evening at which market traders would be packing up earlier. One could reasonably expect that, on the balance of probabilities, had an inspection taken place, it would have been in the earlier half of the 3-hour slot. So we have a 3-hour slot, and in the first 2 hours, an inspection doesn't take place. On the balance of probabilities, had it taken place, one would expect it to take place in the 2/3 section rather than the 1/3 section. And on that basis, I say that's where the causation comes from in that regard, and the judge was entitled to so find.
So if anyone had left poles lying around after 5 o'clock, say, and they wouldn't have been detected until the next day?
That would appear likely on the balance of probabilities. In respect of the nuisance ground, and this is paragraph 23 of Lord Dyson's judgment that I took the court to yesterday. In my submission, that essentially sets out that where a nuisance is established, and in this case, that would be the continuation of a nuisance on the basis that the defendant had knowledge or had means of knowledge of that nuisance, then it is for the defendant to say that it did not have ample opportunity to abate that nuisance. And it's not part, as I understand it, of the defendant's case at the lower court, that there was insufficient time to remove the poles from the place that could constitute a nuisance. So we say the court was, if he's wrong to find on causation on negligence, he was still entitled to find causation on nuisance. These matters are dealt with more fully in my skeleton argument. Unless there's anything further on that ground, or indeed any of the others, my lords, those are my submissions.
Thank you very much, Mr. Coffey.
Grateful.
Mr. Hedgeman.
Lord, my lady, I indicated yesterday that I would be perhaps no more than 20 to 30 minutes. I'm confident that I can close my reply by lunch.
That would be splendid.
There are, in fact, only 2 matters that I intend to
Yeah.
come back on, if I can put it like that. The first is to clarify the position about the witness evidence on what steps would have been taken had these poles been identified. If I can take the court back, please, to page 87 of the core bundle. To the judgment, it's the paragraph we've just been looking at. I want to clarify the point about the contradiction that is said to have existed in the evidence between Mr. Udin, as my lady identified at paragraph 87, and Mr. Patchell, which is paragraph number 20 within paragraph 89 of the judgment. They aren't truly inconsistent. What Mr. Patchell was saying, if I could begin there first, is that what would have happened if these poles had been identified in that location is that they would have been removed to somewhere else on the highway, a convenient or more convenient place. Examples there being in front of a building line, or outside a disused shop. Indeed, I think he gave evidence that if there was a vacant market pitch, they might try and put the poles in the vacant market pitch. So the point there being, of course, what Mr. Patchell is not talking about is removing the obstruction from the highway. It's just moving it to somewhere else on the highway. That
helps the claimant rather than you, doesn't it?
I can see that, my lady, yes. In a way, it gets around the issue of construction about the power to remove that Lord Justice Stuart-Smith.
So the evidence, looking at that evidence, if there'd been an inspection, it would have been moved to a safer place.
That seems to be the position, yes. I think in the first instance that the market officer would try to identify who it belonged to, and they would remove it. So it's not quite as immediate as that. But I think
they wouldn't have just left it where it was if they'd seen it.
yes. So I think that perhaps deals with the next matter I was going to come on to was the cessation of trading point and what that means as a matter of construction. Having reviewed the Act again last night and not found any better answers, I was going to.
Well, given the concession you've just made, it falls away, doesn't it?
I think it probably does. In which case, the last point that I come back to is the point about nuisance taking the claimant further than negligence. Because as I understand it, in the exchange between my learned friend and my lawful Justice Stuart-Smith yesterday, essentially the point that my learned friend makes is that, well, the burdens are different in nuisance, and therefore any difficulties with the case on causation in negligence can be worked around, those are my words, by dealing with the matter as one as nuisance. I will, if I may, just go back to the Ellie Jones authority on this, and really my submission is going to be that my learned friend is taking the paragraph said to support the position out of context. Ellie Jones at tab number 8 of the authority bundle. Now, of course, the facts are straightforward. This is the case where the Portsmouth City Council were contractors who had active control over the tree roots that encroached onto the claimant's property next to the highway from which the tree roots came, and caused subsidence. This was a case about creating a nuisance, not continuing one. It was the City Council who were essentially liable in nuisance for the fact that the tree roots, which they should have contained, encroached onto the claimant's adjoining property. So this case does not, of course, deal with concepts of continuing nuisance where liability can arise. In my submission, it must be uncontroversial that in order to establish liability for a nuisance, a claimant must prove that liability in nuisance is the responsibility of the defendant. In a straightforward case of a nuisance encroaching from land A to land B, where it's an occupier or someone akin to an occupier, that must be straightforward. The difficulty arises where the claimant has to go further and show that there's a continuation because the nuisance has been created by a third party. But that must be for the claimant to prove that the defendant had a opportunity with reasonable care to have identified the nuisance created by someone else and abated it. That must all be uncontroversial. Ellie Jones and Portsmouth contained 3 issues. The first issue was relevant to the liability question in nuisance. That was, as we saw yesterday, the question of whether a contractor who was managing these tree roots and essentially responsible for their growth, whether they were a correct, viable defendant, and the court held that they were. That first issue, issue A of the judgment, deals with the liability question. There were 2 further issues that dealt with points about mitigation of damage. It was said by Portsmouth in this case, well, the expensive works that the claimant owners took for their property to underpin it was unnecessary. That was one argument of mitigation. Another was Portsmouth City Council saying, you did not give us an opportunity to abate the nuisance before you were committed to spending, I think it was £40,000 on the underpinning works.
It wasn't 40, it was 400.
I beg your pardon, yes, 400. So one can see why the mitigation arguments arose. The point that I make, and it's a simple one, is that the passage that Malone and Friend took the court to on page 264 of paragraph 23. In that passage, Lord Justice Dyson, as he then was, said that Mr. Bev accepted rightly, in my view, that the burden of showing that the claimant failed to give Portsmouth a reasonable opportunity to abate the nuisance rests on Portsmouth. And as I say, this was in furtherance of an argument that the claimant shouldn't be entitled to cover for the expensive underpinning works because the Portsmouth should have been given an opportunity to abate the nuisance before they were committed to that expenditure. And that was rejected. But it is the point about burden is it goes to mitigating the damage, the specific loss being claimed for the expensive underpinning works. In my submission, it doesn't, perhaps because liability was established on issue A in this appeal alone, and this is not a case about continuing a nuisance. That doesn't reverse the burden. One can't take a burden on a mitigation point against the defendant in having to allege that the defendant has a burden to prove that it's not liable for continuing a nuisance in the sense that they were able, with reasonable care, to have found and abated the nuisance. So they're different points.
The paragraphs that I'm interested in are 11 and 12 in that judgment. Talking about control over the hazard, whether that offers anything different from the law of negligence.
No, my lady, it doesn't. This goes to the question of whether this goes to the question of who can be liable for a nuisance. Now, in the vast majority of cases, it's going to be the occupier or the owner. But what makes the occupier or the owner liable is their power it's their active control over the source of the nuisance and their power to do something about it. That is why Portsmouth, in this case, were liable as though they were the occupier of the highway because of the very specific and high-level nature of the control that they had over the specific thing that was encroaching. Their management.
This is tree roots escaping from the highway onto neighbouring land.
So it's an encroachment case.
Yeah.
It's not even public nuisance on the highway case.
No, but we've got here poles effectively encroaching from the market onto the parts of the highway that the public use.
Yes, although in law, in my submission, there is no encroachment. There's no emanation. It's simply the depositing of a nuisance on the highway, and this is one of the grounds on which I distinguish the claimant's case, essentially saying that the defendant was able, as a matter of law, to continue the nuisance. But yes, so Eddie Jones perhaps represents an extension, but the common thread is that essentially, in both fact and law, Portsmouth were in control of these tree roots. And my lady may recall that yesterday I took the court through the detail of that. They had a management plan to sort out the crowns of the trees and in turn hoped to reduce the growth of the tree roots.
Is that really different from having a plan to regulate a market?
Well, it goes to the control that they had in fact and law. Essentially, as occupier, with all the tenements of control that occupation brings. In my submission, they
stood in the shoes of the occupier effectively here.
Yes, well, it's slightly different because of course it was a highway, and so the other potential defendant was the highway authority. But in my respectful submission, we are a long way off that situation here, where we're simply dealing with a local authority exercising its statutory function, discharging its statutory powers as it sees fit. That is everything that I intended to say, unless I can insist on that.
Thank you both very much for your assistance. Thank you for completing it in 1.5 days, which is what we thought before the case began it should take. We will, of course, reserve judgment. You know what I'm going to say next. We'll send out a draft judgment. Draft not in the sense that we want points to be argued, but simply for correction of typos and factual errors, if any. The judgment will then be handed down in the digital sense of being placed on archive and so forth. Until it is, then it's confidential to the claimant, obviously, and those in Tower Hamlets who need to know in order to be able to give instructions, but is not to be disseminated more widely. Thank you very much for your assistance.
All rise in favour.